Monday, Judge Hanks just ended the delay game. No more extensions, no more stalling, no more excuses. Order filed this morning. Kash, Patel, and Pam Bondi must hand over the hidden documents immediately. That's today. Not next week, not after another hearing, today. This isn't a warning. This is a direct court order with teeth. Immediate consequence? Both Patel and Bondi are now in a compliance window, and that window is closing by the hour. Numbers: multiple subpoenas, multiple document sets, 0 further extensions granted. But here's what they're missing. Judge Hanks's order forces Patel and Bondi to either comply fully by the deadline or face contempt proceedings that could begin within 24 to 48 hours. That's less than 2 days from now. What Patel and Bondi do next determines whether this stays a civil compliance matter or becomes a full criminal contempt crisis. Because if either one defies this order, the judge has already signaled he will not wait. Dominoes falling. Let me show you the sequence. Quick update from yesterday. Sunday, Judge Hanks issued a sharp warning from the bench that he would not tolerate further extension requests from either Patel or Bondi's legal teams. Both sides had been running the clock for weeks with procedural filings. I said one of two things would happen. Either the legal teams would produce something overnight as a show of good faith, or Judge Hanks would wake up Monday and drop the hammer. Less than 12 hours later, he dropped the hammer. That's not a coincidence. That's a judge who had already made his decision. What changed? Extension strategy is now dead. Hanks explicitly refused any further delay motions. Both Patel and Bondi are now on the same compliance clock simultaneously. The document sets in question are no longer in dispute. Hanks ruled they must be produced. That brings us to today. Judge Hanks's order changes the game from when will they comply to will they comply at all. Here's exactly what happened. 8:14 a.m., Judge Hanks's clerk filed the order to the docket. 8:47 a.m., order formally served on Patel's legal team. 9:03 a.m., order formally served on Bondi's legal team. Documented in federal court docket filings, Eastern District, Monday morning. The sequence matters. Both teams served within the same hour. That's intentional coordination. If Hanks had served them separately with staggered deadlines, would signal room for negotiation. He served both simultaneously. Signals he wants no daylight between them. No one can claim they didn't know what the other was doing. Specific details. The order covers multiple document categories that both Patel and Bondi's teams had previously withheld, claiming either executive privilege review was still ongoing or that documents required additional classification review. Judge Hanks rejected both justifications as having already been litigated and resolved in prior hearings. The compliance window in the order is immediate. Language used is forthwith, which in federal court means without any further delay or precondition. Each detail constrains their options. Forthwith means they cannot file a stay of compliance and wait. They must produce first, then appeal. Rejected privilege claims means they cannot relitigate the same arguments. That door is closed. Leaves full production as the only legal path. And full production means documents that have been hidden are now ordered into the record. The trap. Judge Hanks's leverage. If Patel and Bondi comply, documents enter the record and whatever is in them becomes part of the case. If Patel and Bondi defy the order, contempt proceedings begin and the defiance itself becomes evidence of consciousness of guilt. Win-win for the court. Lose-lose for Patel and Bondi. Evidence of planning. Judge Hanks did not issue this order cold. This follows a documented pattern across multiple prior hearings where he gave explicit warnings that were entered into the record. He was building a foundation for exactly this moment. Not reactive, calculated. Immediate effects. Within 2 hours of the order being filed, 9:22 a.m., Patel's legal team filed a notice of intent to respond, not a compliance filing, a notice of intent. That's a legal placeholder, not production. 9:58 a.m., Bondi's team filed an emergency motion to clarify the scope of documents covered. 10:34 a.m., Judge Hanks denied Bondi's clarification motion in a one-line order. The scope is as previously ruled. Plaintiff's response filed a motion at 10:47 a.m., requesting the court set a same-day compliance deadline and begin contempt clock immediately. Media response. Major legal correspondents flagged Patel's intent to respond notice as a potential delay tactic disguised as compliance movement. Legal reaction. Multiple former federal prosecutors publicly noted that intent to respond is not compliance under a forthwith order. Legal analysts flagged Bondi's scope motion as a near-identical tactic to one already rejected in a prior hearing. Court watchers noted Hanks's one-line denial as a deliberate signal of zero patience. 1 hour and 20 minutes from order filing to judge denying Bondi's delay motion. That's how fast this moved. The speed matters because Hanks is not giving either side room to run procedural interference. Every motion they file is being answered in real time. He came prepared for exactly these moves. Subscribe, this is moving fast. Patel and Bondi responded. Within 3 hours of the original order, here's what they did. Patel's team escalated to the circuit court, filing an emergency application for a stay of the district court order pending appellate review. Bondi's team filed a separate emergency motion in the district court, arguing that producing the documents before the appellate stay question is resolved would cause, quote, irreparable harm. Both teams issued coordinated public statements within minutes of each other, framing compliance as a due process issue. Documented in circuit court filings and district court emergency motions Monday afternoon. Why this matters. This is a coordinated legal strategy. Both teams are working from the same playbook. The appellate stay application by Patel and the irreparable harm motion by Bondi are two flanks of the same maneuver. If either succeeds, they stop compliance. If both fail, they've created a record for a later appeal. Their calculation, what they're trying to achieve, a pause in the compliance clock while appellate review is pending. What they're trying to prevent, the documents entering the record before any appeal can succeed. What they're willing to risk, looking obstructionist on the public record. They've apparently decided that's worth it. Quote from Bondi's filing, production of these materials prior to appellate review would render any future ruling moot. Translation, once the documents are out, they can never be unproduced. That's exactly what they're trying to stop. Whether this works depends on whether the circuit court grants an emergency stay. And emergency stays at the circuit level require showing a likelihood of success on the merits, which means the circuit court has to believe the district court's prior privilege rulings were wrong. That's a steep hill. See the pattern forming? Like this. Here's why this doesn't de-escalate. The mechanism. Judge Hanks issued the forthwith order. That triggered an automatic compliance clock. Patel and Bondi filed emergency stay applications. That triggered the circuit court's emergency review process. Now both parties are locked into a binary outcome with no middle ground. If the circuit court denies the stay, Patel and Bondi must produce documents immediately or face contempt. If the circuit court grants the stay, Hanks loses control of his own docket and the documents go dark until appellate proceedings conclude, potentially months from now. Once Hanks moves to contempt, the record is permanent. Even if an appeal later succeeds, both Patel and Bondi will have contempt proceedings on their federal record. That's the spiral. We're 3 steps into it. Order issued, emergency stay filed, circuit decision pending, compliance, or contempt. The escalation mechanism is structural, not personal. Judge Hanks doesn't have to do anything dramatic. If the circuit denies the stay and Patel and Bondi still don't produce, the system forces his hand. He has no legal choice but to proceed with contempt. Former federal judge and appellate practitioner commentary across multiple legal outlets this morning makes the same point. Once a forthwith order is entered and a stay is denied, defiance isn't a legal gray area. It's contempt. Window for off-ramps? Today. If Patel and Bondi produce even partial documents before the circuit rules, they give themselves an argument that they're in good faith. After that, locked into the circuit court's binary decision. While Patel, Bondi, and Judge Hanks were focused on each other, the Senate Judiciary Committee announced Monday morning that it is opening a parallel inquiry into the same document sets now subject to Judge Hanks's order. Timing of the announcement? 11:17 a.m., less than 3 hours after Hanks's order was filed. Why this complicates things? The Senate Judiciary Committee has independent subpoena power that operates on a completely separate track from the federal court system. Hanks can't control it. Patel and Bondi can't consolidate it with their appellate strategy. Specifically, congressional subpoenas and federal court orders can demand the same documents simultaneously. There is no legal mechanism to pause a Senate subpoena because you're fighting a federal court order. Both run concurrently. What the committee wants. Stated goal: oversight of executive branch document retention and production practices. Quote from committee chair's statement, "The federal court's findings make clear that documents have been withheld from legitimate legal process, and this committee has an independent constitutional obligation to conduct oversight." Their actual interest? The committee is positioning to receive these documents directly if the federal court process gets bogged down in appellate delays. If Patel and Bondi succeed in pausing compliance to Hanks, the Senate has its own subpoena running parallel. Evidence the committee's document requests are structured to mirror the exact categories in Hanks's order. This wasn't drafted overnight. It was prepared in advance and timed to this moment. Impact on Patel and Bondi. Even if they win the appellate stay today, they now face two separate compliance demands with two separate enforcement mechanisms. Impact on Judge Hanks. Congressional parallel inquiry publicly validates his findings and creates political pressure that makes the circuit court's stay decision more visible. Neither saw this coming in the form it took. The timing, 3 hours after Hanks's order, was not coincidental. This gets more complicated. Stay with me. Step back. What's actually happening here? Patel's strategy: buy time through appellate process. Get the circuit to pause everything while a longer appeal plays out. Willing to sacrifice public perception of compliance, the appearance of transparency. Bondi's strategy: use procedural motions to create ambiguity about what must be produced and when. Exhaust the court's patience by making every step contested. Willing to sacrifice her relationship with the federal judiciary, institutional DOJ credibility on document handling. Senate Judiciary strategy: create a parallel compliance track so that even if the appellate courts give Patel and Bondi relief from Hanks's order, there's no escape from oversight accountability. Willing to sacrifice coordination with DOJ, risk of executive branch pushback on congressional oversight authority. Where strategies conflict, Patel needs appellate cover to avoid producing. Bondi needs procedural ambiguity to delay producing. Senate Judiciary needs production to happen and benefits if the court process fails because it validates their independent inquiry. No compromise satisfies all three. Means documents either come out through one process or the other. The question is, which process gets there first? Expert analysis. Former federal appellate attorney. Commentary this morning. Emergency stays of forthwith orders are rarely granted when the underlying privilege questions have already been litigated and decided. Translation: the appellate maneuver is legally weak. It's a delay mechanism, not a likely winner. Even legal commentators who have been sympathetic to executive privilege arguments in other contexts have noted a forthwith order following multiple prior rulings on the same documents is on very strong legal footing. When analysts across different perspectives agree the appellate path is a long shot, that's the read. Fair counterargument. Patel and Bondi's defenders argue that the appellate process exists precisely for situations like this, where a lower court order carries significant executive branch implications. They argue rushing production before appeal is resolved undermines the entire privilege review system. That has merit. But the specific documents at issue have already been through privilege review in prior proceedings. This isn't a first instance privilege claim. Hanks's order reflects rulings that already happened. The appellate argument isn't really about privilege anymore. It's about delay. Both sides argue. Actions reveal. Filing an intent to respond notice instead of actual compliance and simultaneously running to the circuit court is not the behavior of parties who believe they're legally right. It's the behavior of parties trying to run out the clock. This pattern isn't new. 2012, Attorney General Eric Holder was held in contempt by the House over Fast and Furious documents. Holder's DOJ initially refused compliance, citing executive privilege. Congressional pressure escalated. Emergency legal maneuvers were filed. Result? Partial production eventually happened. Contempt vote passed, but was never criminally enforced. Some documents remained withheld for years under ongoing privilege claims. Timeline: 18 months from initial refusal to any meaningful production. The full dispute stretched years beyond that. Key difference then? That was a congressional contempt proceeding, not a federal court order. Congressional contempt enforcement is politically dependent. The DOJ simply declined to prosecute its own boss. Federal court contempt is structurally different. Judges enforce their own orders through their own authority. But the dynamic? Same. Executive branch officials withholding documents, escalating legal maneuvers, emergency appeals, time as the primary weapon. Legal historians who covered that case have noted consistently the lesson of Fast and Furious was that delay works if you have enough runway. We're at the initial refusal dressed as procedural compliance stage now. If history repeats, Patel and Bondi string this out for months through appellate processes. Some documents eventually produced, the most sensitive materials remain contested. If it breaks, Judge Hanks would need to move to actual detention or coercive contempt, which is extraordinarily rare for senior executive branch officials, but is legally within his power. Like, if you're following this thread, why this matters. If you've ever assumed that court orders mean compliance, what's happening right now is a direct stress test of that assumption at the highest levels of government. Think about what a court order means in practice for anyone else. If a small business owner ignores a federal court order to produce documents, the process is swift. Contempt, sanctions, production enforced. There is no file an emergency stay and wait. The question this case is forcing into the open is whether senior executive branch officials operate under a fundamentally different compliance reality than everyone else. Not as a theoretical matter, as a live, documented, this morning matter. Before today, that question was abstract. After today, it has a specific judge, specific names, specific documents, and a specific order that is either being followed or it isn't. The precedent, whether forthwith, means the same thing for a cabinet-level official as it does for anyone else. Bottom line, if you believe the rule of law applies equally, regardless of who you are, this morning's order is either going to confirm that or expose the gap. The compliance window is open right now. What happens in the next 24 to 48 hours will answer the question. If you pay attention to how power and accountability actually work in this country, this connects directly. What happens next? Monday afternoon, today, Circuit Court must decide whether to grant Patel's emergency stay application or deny it. Emergency applications at the circuit level typically get a response within hours to a day. 3 possible outcomes. 1, circuit denies the stay. Patel and Bondi must produce documents today or face immediate contempt proceedings before Judge Hanks. 2, circuit grants the stay. Production paused. Hanks's order is frozen while full appellate briefing is scheduled. This buys weeks to months. 3. Circuit grants partial stay. Some document categories must be produced now, while others remain under appellate review. Legal analysts this morning say outcome 1 is most likely, because emergency stays of orders where underlying privilege questions were already adjudicated face an extremely high bar. The circuit would essentially have to find that Hanks got the prior privilege rulings wrong. Also on the clock, Monday to Tuesday, Senate Judiciary Committee's formal subpoenas are expected to be served on Patel and Bondi directly, separate from the court proceeding. Tuesday morning, Judge Hanks has indicated he will hold a status conference if compliance has not begun by end of Monday. That status conference is the contempt proceedings gateway. Wednesday, if no compliance and no stay, contempt hearing likely scheduled for this week. These connect because if the circuit denies the stay today, Tuesday's Senate subpoenas land on Patel and Bondi while they're already in contempt posture with the federal court. If the circuit grants the stay today, Senate subpoenas become the only active compliance mechanism and the hearing dynamic shifts to Capitol Hill. The two tracks, judicial and congressional, are moving simultaneously and will intersect by Tuesday. Wildcard. Patel or Bondi produces partial documents unilaterally tonight. Not because they're legally required to with a stay pending, but as a strategic show of good faith to influence the circuit court's emergency stay decision. Partial production wouldn't moot the stay application, but could change the optics enough to affect how the circuit frames its order. Countdown. Circuit stay decision. Likely within 12 to 18 hours from now. Senate subpoenas served 24 to 36 hours from now. Judge Hanks' status conference 36 to 48 hours from now. Contempt hearing, if no compliance, 48 to 72 hours from now. By Tuesday morning, we'll know whether the circuit gave Patel and Bondi their lifeline or sent this straight into contempt. Subscribe. I'll break down the circuit court's stay decision the moment it drops. Where we are right now, Judge Hanks's forthwith production order is in effect as of this morning. Patel's team filed an emergency circuit stay application. Circuit has not yet ruled. Bondi's scope clarification motion denied in one line by Hanks. Senate Judiciary Committee parallel inquiry announced, subpoenas being prepared, no documents have been produced as of this recording. Active clocks, circuit stay decision, 12 to 18 hours remaining. Senate subpoenas served, 24 to 36 hours remaining. Judge Hanks' status conference, 36 to 48 hours remaining. Contempt hearing, if applicable, 48 to 72 hours remaining. Moving pieces. Patel, waiting on circuit stay, not producing. Legal team in active emergency appellate posture. Bondi, denied on scope motion. Emergency irreparable harm filing still pending response, not producing. Judge Hanks, order issued, watching clock. Status conference already on his calendar for Tuesday. Senate Judiciary, subpoenas being finalized. Timing coordinated to land regardless of circuit outcome. Locked variables. Judge Hanks's prior privilege rulings stand, cannot be relitigated at the district level. That argument is done. Open variables. Whether the circuit grants a stay. Whether either Patel or Bondi moves to partial production tonight as a strategic gesture. Whether Senate subpoenas create a separate compliance obligation that the stay doesn't cover. Momentum. Escalating toward Tuesday morning status conference. 3 things I'm tracking. 1, the circuit court's emergency stay ruling, specifically the reasoning, not just the outcome. If they deny with a written explanation citing the prior privilege rulings, that language becomes ammunition for Hanks's contempt proceedings. If they grant even a narrow stay, watch what categories of documents they carve out. That tells you exactly what the appellate court thinks is actually at risk here. 2, whether Patel and Bondi's legal teams are coordinating or diverging. So far, they've moved in sync, same-day complementary filings. If one of them breaks from that pattern and moves toward production independently, it means someone blinked and the united front is cracking. 3. The Senate Judiciary Committee's subpoena scope when it's formally served. If it mirrors Hanks's order exactly, they're creating a redundant enforcement backstop. If it goes broader, they're using this moment to expand the inquiry into territory the court case doesn't cover. That's a significantly different situation. Monday evening is the inflection point. That's when we'll know if the circuit gave Patel and Bondi their stay, or if Tuesday morning opens with Judge Hanks running a contempt proceeding. I'll be covering the circuit decision and Hanks's response the moment it happens. See you then.